International humanitarian law, also sometimes called the laws of war, prohibits all forms of sexual violence, and this is a prohibition that applies to all parties to all armed conflicts. The term sexual violence describes any act of a sexual nature committed against any person by force, threat of force, or coercion. And coercion can be caused by circumstances such as fear of violence, duress, situations of detention, psychological oppression, or abuse of power. Rape is a specific form of sexual violence, but sexual violence also includes other acts such as sexual slavery, enforced prostitution, forced pregnancy, and enforced sterilization. Sexual violence in armed conflict is prohibited no matter the gender of the victim or who the perpetrator is, whether civilian or military, and everyone is equally protected by this prohibition. While women and girls constitute the majority of victims and survivors, men and boys are also affected. First, parties to conflicts must prevent sexual violence from happening in the first place. This concerns notably their armed forces and others acting under their control. So sexual violence prevention must be part of the training of the armed forces. Second, if sexual violence occurs, international humanitarian law requires that victims and survivors, like all wounded and sick people, receive medical care to the fullest extent practicable, with the least possible delay and without discrimination. Finally, sexual violence is a war crime, which states must investigate and, if appropriate, prosecute. This requires having legislation in place that allows them to prosecute the perpetrators. International law unequivocally prohibits sexual violence and provides the legal framework to effectively prevent and respond to sexual violence in conflict. What needs to be improved for it to be effective is to ensure that domestic laws and institutions reflect these international obligations and create conditions conducive for survivors to come forward.